Hi, everybody. Welcome to another episode of Pretty Lies and Alibis. I'm Gigi for Root Loop. What you know?
Did you know that apple pie isn't actually American at all?
Really?
When I read this, I was like, shut up. What the world? No, so apple pie. So, you know, like the saying, it's something is as American as apple pie?
Mm-hmm.
Oh, apple pie ain't American. It came from England. And apples actually originated in Asia. So we didn't even have apples here.
My whole life has been a lie.
Exactly. Apples ain't American.
Oh,
There
boy.
you go. It'll be on Jeopardy, I'm telling you.
Yeah, and we also know that the creator of the electric chair was a dentist.
See, exactly.
There we go. Yep. So I went to the gym today.
Yeah, you just sent me a gif of a sloth because your computer was running slow, and I said that's gonna be you in the morning.
My kids are likely going to be late to school because I cannot get my butt out of bed. Look,
Yeah,
you know it's bad when you're sore before you even walk out of the gym.
yeah, that's bad.
Not even kidding. Okay. So let me just say, I'm kind of thinking at this point I should embrace the mom belly because look, I grew and birthed 3 actual humans. I'm going to tell you, I felt so out of place. Literally, half the people in there weren't even working out. They were in the mirrors, like filming TikToks and taking selfies.
I bet so.
But of course, if my belly looked like it did at 20, I'd probably be in that mirror too. I'm just
Hey,
saying.
I ain't gonna
Yeah.
lie. I like to eat apple pie, so I don't care.
Okay. So, you know that machine that you put your legs in and then you close your legs? Right.
Hmm.
It's like an adduction machine or something.
Yeah.
Dude, I got my leg like I was in stirrups, right? I could not even close the thing. I'm sitting there and like I'm like this, and I'm like, huh.
That's not good. You
Oh
gonna be like
no,
them people you see those videos of somebody running on a treadmill and they fall off or something.
dude, I was limping in my car. Not even lying. And everybody called me ma'am. I was like, I'm not supposed to be here.
Uh,
So I stopped and got me a milkshake because I deserve it. Anyways, so if you guys follow us on social media, I have to talk about this story that I tweeted out today. Okay, let me see if I can show this picture of this guy. Right.
oh, I saw it and I laughed.
Okay, so you see this guy right here? Okay, so the city of Cincinnati government put a post out. The fugitive task force is looking for Ronnie Williams Jr. of Cincinnati for fraud. He has convinced 3 local churches that he is Ed Sheeran and even went as far as to perform The Shape of You in front of Christ Community Church last Sunday.
Dude,
When the pastor asked why he believed the real Ed Sheeran would perform for $35 and a sandwich, he said he just assumed he had fell on tough times. If you have any information as to Ronnie's whereabouts, message us immediately.
dude, that mother got paid $35 and a ham sandwich.
A hand sandwich.
Hey,
I want to see a recording of that. I'd pay good money.
yeah.
So we want to give a shout out to one of our sponsors, Too Cool T-Shirt Quilts. You can go to toocooltshirtquilts.com/pretty lies and alibis. Check it out. Graduation season's coming up. I think wedding season's coming up. All kinds of things that, something unique, something really cool. So go to toocooltshirtquilts.com/pretty lies and alibis. She'll know we sent you.
And they can take your t-shirts and make them into a quilt that is too cool. You like how I introed that?
I have a hitchhiker thumb. Look, that bad boy. Well, it's because my joints are all messed up. But like, look,
Oh, yeah, you got weird joints. I don't.
your
Like,
mama got weird joints.
so my
Okay.
mom broke her thumb one time, didn't even know it, and now it's like crooked. And one time I was looking at her thumb, I was like, "What's wrong with your thumb?" And she said, I think I broke it one time. Like she was an adult when she did it.
Oh my God, that's my dad. My dad don't feel pain at all.
Yeah.
And one time he taught karate, and we had a garage in my childhood home in the backyard, and he had a little dojo, and like he used to travel and do karate. He was awesome. And one night he came in and he had something on his foot, so he like licked his finger. We were all sitting there eating supper, and he said, "I got something on my foot," and he like stood up and put all of his weight on it, and his bones just crumbled.
That's
He had no
crazy.
clue. And one time he hit something with his finger, and that thing was pointing like totally
Mhm.
to the side. And we were like, "Dad, your
That's
finger." I was like,
that's
"Oh,
football
yeah."
player syndrome.
Yep. So there's been some, by the way, there was a little update about Alexis Ware, the local girl that's missing. It was a non-update update. Essentially, they said they have checked out the leads that they've been getting. So far, like no word, nothing at all. Crazy case. Now, if you guys remember, John Pryor filed the motion to sever. And so we just got the state's response for that. So we're going to go through that. We were going to do these text messages between Lori and Zulema. I'm still working on those, and I had enough ready for tonight, but this kind of, we're just keeping current with the case. That's sort of older stuff. So it was a long response. It was like 20-something pages.
Yeah, I think 26 or something.
It was a lot. So we're just going to go through that, and then we have a quick Barry Morphew update. And then tomorrow we'll do the text messages, and then I think by Thursday we'll catch up on Dr. Husel's trial. So in the beginning, they just have a factual and procedural background on the case, which is on May 24th, 2021, a grand jury returned a single indictment against the defendants Lori and Chad, containing a total of 9 criminal charges relating to the murders of Tylee, JJ, and Tammy. On June 9th, Chad was arraigned in the presence of his counsel. I got to bring that out. On all of his charges in the indictment. Defendant Lori Vallow has not been scheduled for an arraignment at this time since her proceedings are stayed. However, she has been appointed death penalty qualified counsel and has the assistance of counsel at all times. On August 26, 2021, the court issued an order indicating that while the cases would be tried in a single trial, the proceedings would be conducted separately in each case. The order instructs the parties to only file respect. Dude, I need ice. I ain't gonna lie. I need a heating pad and some ice. I'm not comfortable. Sorry, y'all. Oh, I just paid for that whole membership too. I'm thinking about not even going back.
Dude, that's why you do $10 a month. You do it monthly. I'm skipping 5 months.
Yep, that's me. So, on August 6, 2021, the court issued an order indicating that while the cases would be tried in a single trial, the proceedings would be conducted separately in each case. The order instructs the parties to only file respective pleadings in the individual cases, even though the order indicates they will be tried together. The August 6th order recognized the joinder was proper under Idaho Criminal Rule 8. Chad filed his motion to sever on September 7th, 2021. The initial trial date set by the court was November 8th, 2021. However, that was vacated after receiving Chad's signed written waiver of his right to a speedy trial on August 20th. And it's kind of funny because, one of the arguments Pryor made in one of the last hearings was that he's been in jail a long time, but he signed his waiver to a speedy trial. So not sure.
Yeah, there, buddy. You should have.
Not sure what that argument was. The change of venue motion was argued on October 5th, and on October 8th, the court issued a written order granting the request for Chad. No order changing venue was entered in Lori's case due to the stay in her case. The trial was set for 10 weeks beginning January 23rd, 2023. So let's get into the law and argument.
Yeah, and this is stuff that is crazy, and sometimes we don't understand it, but we're going to try. So, joinder of defendants. 2 or more defendants may be charged on the same complaint, indictment, or information if they are alleged to have participated in the same act or transaction or in the same series of acts or transactions constituting an offense or offenses. The defendants may be charged in 1 or more counts together or separately, and all of the defendants need not be charged in each count.
And that's in this case because, for example, Chad has the murder charge for Tammy, but Lori's only charged with conspiracy to commit murder. Chad has that one as well. And then Lori has some kind of a fraud charge for the Social Security, where Chad has like insurance fraud. There's, there's some differences, but
it's basically the same evidence, basically.
Exactly. Yeah.
So the propriety of joinder is determined by what is alleged, not what the proof eventually shows. And they cite U.S. versus Roselli, which is the offense and defendants may be joined even though not all defendants participate in every act constituting each joined offense. When you read that, you're like, okay, what evidence do you have? What are you wearing?
Counting crows.
Oh, I was doing that today at the doctor. I was counting crows on the line. What about that? So the goal of maximum trial convenience consistent with minimum prejudice is best served by permitting initial joinder of charges against multiple defendants whenever the common activity constitutes a substantial portion of the proof of the joined charges. It's further been established that even when the binding count, which furnishes, or court, binding court, probably binding court, court count, something, I don't know, which furnishes the basis for initial joinder fails, misjoinder is not implied, and a conviction will not be reversed for failure to sever unless prejudice is shown. And I think that's probably the big thing that everybody's worried about. If they don't sever, can they come back and say something needs to be reversed?
I mean, they would have to have a really big reason, I think. I
Yeah.
don't think that Judge Boyce is going to make a decision that he's not absolutely sure is not going to end up in some kind of an appeal or a reversal. There's too much at stake here.
Yeah.
But I get what you're saying. I mean, I'm always nervous about this kind of stuff with trials. You know what I mean? Especially because I haven't really covered a lot of co-defendant trials, to be honest.
Yeah. And we're going to talk a little bit about what Scott said. A couple of things he said may get some good points on in a little bit. But
yeah, Scott Reich. I'll tweet that out. And I'll put it on Facebook. I don't think I've done that yet, but we always go to Scott when we have questions.
He did a quick little thing. So
he delivers.
So Chad has not alleged the charges, or he and Lori are improperly joined under Section 8, reviewing the proper nature of the joinder of the indictment, and the case establishes clearly that no severance is warranted. The grand jury's finding of sufficient evidence to return a true bill on the charges for both Lori and Chad validates the overt acts outlined in the indictment taken in further of the conspiracy by the defendants.
Can I just apologize for my sloppy work today? Because my brain just stopped functioning after like the 20th minute of me rowing my little boat.
Changes, charges, it's okay. It's the same thing.
Sorry, my bad.
No, it's all right. So the indictment shows a pattern of planning steps and overt acts taken by Chad and Lori jointly and individually in their unified plan to accomplish illegal objectives, and have been properly joined in a single indictment based upon their participation in the same series of acts. That's the biggest statement, I think.
Mm-hmm. Yeah, I mean, they're very fluid, and they have been the whole time. And so, I don't know. I just feel like if her competency or incompetency is extended one more time, I think that's where you get into that. It's just going to have to sever on its own. Because at what point, what you don't want is to schedule this trial in another county hours away and then, say, oh, we have to continue, we're going to have to move this to another date for whatever reason. I don't know at what point her attorney is going to say, look, I haven't been able to talk to her because she can't assist in her defense right now. At what point is that going to be a problem where this motion to sever is kind of a moot point, because it's going to happen probably if this is continued again.
Yeah. And Scott said today, he said that there's times where it's not unusual for a trial to start and the other co-defendant not to be there. It could be different things. It could be they made a plea deal. Mm-hmm. It could be they haven't been caught yet. It could be, several reasons. They're in a mental place or whatever. But he said it's not uncommon to start the trial.
And what I wonder too is, in that case, is it going to be the same jury that eventually will hear her case?
Yeah, it'd be bad.
It's going to be terrible if this is, I mean, really, I don't think, if this thing organically separates because she's not competent and time's ticking, I mean, it's just going to be a disaster.
Yeah.
In some ways, I mean, Chad will get his and she'll eventually get hers, but it's just like Kay and Larry and Krisha and Colby and and Annie and everybody, they're going to have to do this twice. The witnesses are going to have to do it twice. And then what you're going to find is Lori's attorney has a leg up because then she knows what the prosecution's gonna have on her. So then if they don't go to trial together next January, her lawyer has got a little bit of a benefit to know what angle they're going to go at.
Exactly.
Yeah.
Yep. And maybe that's their goal. I don't know.
It could be. And then you think about witnesses that any slight variation in their testimony is going to be picked apart by her attorney at a later time. It's just for a million reasons is bad.
Yeah. I'm still sad we don't get to see Means on the Means show has ended.
Yep.
Like, yeah. Don't give us
That's
much
over.
about.
He's been quiet a little bit. He tweeted a little bit the other day, but nothing about the case, I don't think.
Yeah.
He took a jab at somebody.
All right. So
I'm sorry, we just went on left field.
We did. We took a road detour. It's like Bob's Road or something.
So Chad Chad has made no argument or allegation that either the charges or that the defendants were improperly or impermissibly joined. There's no evidence to suggest the charges or Chad and Lori were improperly joined in the single indictment. Chad argues the case should be severed under Idaho Criminal Rule 14 due to prejudice. Rule 14 says if it appears that a defendant or the state is prejudiced by a joinder of offenses or defendants in a complaint, indictment, or information, the court may order the state to elect between counts, grant separate trials of counts, grant a severance of defendants, or provide whatever other relief justice requires. In ruling on a motion by a defendant for severance, the court may order the attorney for the state to deliver to the court for inspection in camera any statements or confessions made by the defendants that the state intends to introduce in evidence at the trial. Chad has the burden of showing prejudice. Ohio courts have considered 3 potential sources of prejudice later identified in State versus Abel as follows. Number 1, the jury may confuse the evidence and convict the defendant on one or both crimes when it wouldn't convict him of either if it could keep the evidence segregated. Number 2, the defendant may be confounded in presenting defenses as where he desires to assert his privilege against self-incrimination with respect to one crime but not the other. The jury may conclude the defendant is guilty of one crime and then find him guilty of the other because of his criminal disposition. Joint trials serve the interest of justice by avoiding the scandal and inequity of inconsistent verdicts and enable more accurate assessment of relative culpability. Good Lord in heaven. I cannot talk tonight.
Dude, you do some kind of workout? You do push-ups with your tongue or something?
I know. I think my tongue got very muscular today. Advantages which sometimes are to the defendant's benefit. Now, here's the thing. I think they got to point fingers at each other to some degree in this trial.
I agree.
Yeah.
I agree. And that's what part of Scott said today. He said, we don't know what Pryor is and what Daybell's defense is going to be, but he said he can almost assume it's going to be she did it and Alex did it.
Yep.
Is the only defense you can have, basically.
It really is. And all Lori's defense can be is, really is, look, he brainwashed me. Look at my history. I might have been 50 Shades of Grey, but I didn't kill anybody. You know what I mean?
Yeah.
I just don't see how else they're going to defend it. Just blame the finger, point the finger at the dead guy is what they're going to do, which is hogwash.
Well, and that's part of, by the time we get through this, we ain't going to have to discuss any more Scott stuff. But, some of the stuff he talked about today was just finger pointing and having inconsistent theories with each other does not grant a severance.
Right.
Like there has to be proof that there's not going to be a fair trial if you don't sever.
Right. And the courts don't care about their arguments or finger pointing. All they care about is that these are the same set of facts for both of them for the most part, with a little variation on that murder charge for Tammy and the fraud charge for Lori. Other than that, the court don't care. They can point fingers all day. They can sling mud, throw pencils, spitballs at each other.
Yeah.
But, the courts, all they care about.
We want to see them both spend the rest of their life in jail. So.
And it's going to happen. That's the thing. They're not going to get off. This is, but man, it feels like just forever. This case is on forever.
So keep it going with the law stuff. So joint trials also avoid prosecutors bringing separate proceedings, presenting the same evidence again and again. And that's what we talked about. Witnesses and victims. It's a huge inconvenience. and it's very traumatic.
Yeah.
To have to, keep doing that. So the Ninth Circuit Court of Appeals has provided a 4-part test to aid a district court's determination of whether severance is appropriate. The first one is whether the jury may reasonably be expected to collate and appraise the individual evidence against each defendant. 2, the judge's diligence in instructing the jury on the limited purposes for which certain evidence may be used. 3, whether the nature of the evidence and legal concepts involved are within the consequence of the ordinary juror. Whether the defendants could show a risk that the joint trial would compromise a specific trial right of one of the defendants or prevent the jury from making a reliable judgment about guilt or innocence. On a Rule 14 motion, the burden of demonstrating prejudice rests on the defendant and is a heavy one when a conspiracy was charged, which Chad and Lori are. Most evidence against one defendant is admissible against the other, even in a separate trial, as proof of the conspiracy. The court determined that even if some evidence would not be admissible for one defendant, it can be against another, and the prejudicial effects of evidence relating to the co-defendants should be neutralized by careful instruction by the trial judge, instructing the jury to separate evidence. That's tough, though.
Yeah, it really is. And I mean, on paper, that's how it's supposed to be, but is it really going to happen in a courtroom? No, probably not.
Yeah, I mean, that's very tough to separate.
It's just like when something's said in court and the judge tells the jury, like, forget you heard that. Well, it's good in theory, but I ain't going to forget I heard that.
Yeah, it happens on that show Bull all the time. The defense will say something and be like, "Oh, never mind, strike that judge. Okay, I don't want." You know what I mean?
Yeah, but I mean, really,
it's sad. Yeah.
Yeah.
So the elements of conspiracy are the existence of an agreement to accomplish an illegal objective, coupled with one or more overt acts furthering the illegal purpose, and intent necessary to commit the underlying offense, which we know they did.
Yep. So defendants are not entitled to severance because they have a better chance of acquittal in separate trials. Rules 8B and 14 are designed to promote economy and efficiency and to avoid multiple trials as long as these objectives can be achieved without substantial prejudice to the right of the defendants to a fair trial. A defendant normally would not be entitled to exclude the testimony of a former co-defendant if the court did sever the trials, and we see no reason why relevant and competent testimony would be prejudicial merely because the witness is also a co-defendant. Chad has not provided any support that any claimed prejudice is of such a nature or concern as to outweigh paramount interest of judicial economy and efficiency, nor has he provided any support that severance is the only or appropriate remedy over other potential remedies which the court may apply. The only argument with regard to prejudice provided by Chad is the possibility of evidence regarding Lori's pending charge in Arizona for Charles's murder being presented at this joint trial. And that's really easy because all Pryor has to say is, guess who didn't get charged in that murder? My client. He has no charges for murder. You know, so anyways, the court has established there are other remedies short of a complete severance, including limiting and clarifying jury instructions. There have been no evidentiary rulings regarding the speculation being offered by Chad supporting his severance request, and it is unknown what evidence is being referred to, whether the evidence would be admitted and or whom the evidence would be admitted against. Without more information, the argument falls short of the high burden Chad has in requesting a complete severance. Chad has failed to provide a claim sufficient to justify his request that the state provide the court in-camera statements or other evidence it intends to offer in order for the court to conduct an analysis.
Yeah, so, I mean, basically, Pryor has issued a generic, request that was unfair.
Right, but nothing specific. So give me an example of where he's extremely prejudiced. That's what they're saying, is he hasn't given any reason to do this. The last part of this says Chad has been in possession of the discovery for quite some time and could just as easily provide evidence to the court in a sealed filing to support his claim, and no such evidence has been provided by the defense.
Yeah. So there's no Burton issue at this time. So Burton versus United States protects a defendant from incriminating out-of-court statements of a co-defendant being used against him in a joint trial where the co-defendant does not take the stand and thereby becomes subject to cross-examination. There's been no specific argument by Chad that there exists a Burton issue. He alludes to the possibility by requesting any statement or confessions which the state may intend to use at trial be examined in camera by this court. Even if there were a Burton issue, this does not automatically require a complete severance of the trial.
I don't know if it's Bruton or Burton.
Bruton or Burton.
I think it's Bruton.
You know, we mess names up. So
I think autocorrect got a hold of that, to be honest. So sorry.
Sorry, people.
I'm not going to go to the gym before I do notes anymore, Fruit Loop. You see, I lost my mind today.
Well, you was in the gym on a treadmill when you did this.
I'll be walking like the Tin Man tomorrow.
Squeak. In State versus Beam, the Idaho Supreme Court held a district court's decision to impanel 2 juries to hear co-defendants' cases where the jury were employed by the court to avoid prejudice to the 2 defendants for reasons of judicial economy. They state another case, United States versus Lacey. The U.S. District Court for the District of Arizona found that since the defendant failed to provide any statements made by her co-defendants, and there was no indication or evidence that any of her co-defendants had provided a confession implicating her, so there was no reason to sever. Dude, Wood did his homework.
Again. Always. Yeah, he does. He always does his homework. Because, you know, he just wants to be one and done with these filings.
Yeah.
One hearing, we're done.
Here's all my information.
Him and Lindsay Blake both are very smart, and I know they've got their hands on this. I'm not worried.
Yeah.
But I can't wait to see them in action, though. It's like we've seen them at hearings, but like to see them in trial, because you know I think this is very personal for Rob Wood.
Yeah, I think so too.
Yeah, it's going to be very passionate.
Yeah. So I mean, he continues. Further redaction of any confession or statement which removed any reference to the defendant, in addition to a limiting jury instruction, could be enough to alleviate. See, I was getting there. Alleviate any potential prejudice without making a separate trial the only remedy.
Yeah, so we're almost done with this. And this is kind of just, I don't want to say boring, but it's still very important to the case.
Yeah, it's important, but it's the legal mumbo jumbo that is
right.
Yeah.
Yeah. So essentially, like, was just saying, you ain't got enough goods to sever. But statements of co-conspirators and furtherance of a conspiracy are admissible against all conspirators. Idaho Rule of Evidence 801 excludes from the definition of hearsay a statement by a co-conspirator made during the course and in furtherance of the conspiracy. Chad has not provided any statement or confession by his co-defendant which he believes implicates him or any concern that she may provide a statement which he will not be allowed to cross-examine her on. Further, even if there were such a statement, case law outlines that other remedies should be and can be considered short of a complete severance of the trials. Antagonism between defenses or the desire of one to... Oh my gosh. Dude, we didn't start this whole thing over.
I'm so rolling.
Oh my gosh. And I can't look at you because then I'm gone for 5 minutes solid, you know.
Yeah, I'm over here. It's funny. We're going to start sending out our notes, guys, so you can follow along. And
no, this is just the worst one. This is, I don't know, dude. I don't know what happened to my brain during this, but the risk of prejudice posed by joint trials may be cured by proper jury instruction. Chad has not indicated that he and Lori intend to introduce antagonistic defenses, let alone defenses which are so contrary that the only remedy would be a complete severance. So I thought that was interesting. So as of right now, I guess Rob Wood knows or hasn't been told that they're going to be at odds. And maybe he wouldn't know that before trial, but I I thought that was interesting.
Yeah.
It would depend on the length of the delay, the reason for the delay, whether Chad asserted his right, and whether he suffered prejudice as a result of the delay. And what they're saying too here is that Chad waived his right to a speedy trial. So that's kind of what the whole thing said, which, I mean, just to boil it down, is Wood saying, we don't need to sever. If there are problems, which you guys have not given us any yet, that would warrant a severance, there are other ways to avoid completely severing these trials, given the fact that, you know, taking the fact that she's incompetent right now completely out of the equation, which I think that is the equation that's going to be, I mean, we've got a couple of weeks till we should know whether or not it's extended, or are we going to have a first appearance this month? Maybe.
Yeah. And I think the only other thing that Scott talked about was what he thought Boyce would do. And he said he thinks the judge will rule there's no prejudice. There's no inconsistent theories of defenses at this point. And right now you only have one defendant. So, and then we talked about it's not uncommon for conspiracy trials to start without one of the co-defendants. And he said the judge is going to say, look, this isn't ripe yet. It's not ready. There's not enough facts to, you know, sever this case. So he thinks Wood will win this one.
Yep. Well, that's all, you know, interesting stuff. I think we're going to know a lot more when this extension is up in a couple of weeks. And then, you know, I'm keeping an eye out on the portal to see if anything new's filed, and it's been pretty quiet. So we had a little bit of Barry Morphew news. Now, we'll probably go more in depth with this at some point later in the week, but I thought this was interesting today. What was said
in the motion to dismiss documents unsealed today? Agent Cahill, in a December 2nd internal affairs interview regarding him accidentally shooting himself while off duty, said that arresting Barry was premature and the worst decision that could be made. Barry's attorneys say the state withheld exculpatory evidence from the court during his preliminary hearing, saying if that had been available, their certain probable cause would not have been found. The motion asked the judge to dismiss the case for outrageous governmental conduct. The DA responded in a filed response on February 23rd, calling the defense motion utter nonsense, saying the motion to dismiss amounts to disagreements among law enforcement and timing. They also say the prosecution committed no discovery violation regarding Agent Cahill's statements, saying at no time did Mr. Cahill say that he did not think there was probable cause to arrest, or that he thought the defendant was not guilty of murdering his wife.
Yeah, but I'm going to tell you, I thought that was a pretty big statement by him, because he was one of the main guys that was interviewing Barry for a very long time. And if you've watched legal shows that have legal analysts on there, that seems to be sort of a common theme, where they do think that this arrest was rushed in a big way. And we shall see. I mean, that trial's coming up in April. It's not going to be long. It's going to be a good one to follow. I've said it every time. I mean, I've seen circumstantial cases get a conviction. It's just going to depend on that jury.
It'll be interesting.
It's going to be very interesting. All right, guys. Well, we are done. Thank you, Jesus, because I was on the struggle bus from the time we hit record.
That's all right. Just don't go work out.
Dude. I got my icy hot by my bed.
Yeah.
So I'm ready to go.
Video in the morning.
Yeah. All right. Well, we will see you soon, and thanks for bearing with us. We will see you soon.